A historic Supreme Court ruling sending the decision back to the states.
Now South Dakota voters are deciding the future of abortion access. We're highlighting discussion over division by sitting down with people on both sides of the issue.
Dakota News Now and KOTA Territory News present the South Dakota debate on abortion access. Well, good evening and thank you so much for joining us tonight. I'm Brian Allen with Dakota News Now in Sioux Falls.
And I'm Alicia Garcia with KOTA Territory News in Rapid City. In less than 2 weeks, South Dakota voters will decide whether to restore abortion access in the state. It's a discussion that has divided people of all political backgrounds and religious faiths.
Tonight we're bringing that conversation to you with people from both sides of this very important issue. Join us this evening, State Representative and Co-Chair of Life Defense Fund, John Hanson, and speaking on behalf of Dakotans for Health, former State Senator Nancy Turback, and we thank you both for being with us here tonight. Before we get started, let's set the table. South Dakota voters will find this measure on the ballot as Amendment G. The amendment establishes a constitutional right to an abortion and provides the legal framework for the regulation of abortion. Andrea Anderson has a breakdown of Amendment G.
According to the Attorney General's explanation, the amendment establishes that during the first trimester, a pregnant woman's decision to obtain an abortion may not be regulated, nor may regulations be imposed on the carrying out of an abortion. In the second trimester, the amendment allows the regulation of a pregnant woman's abortion decision and the regulation of carrying out an abortion. Any regulation during the second trimester must be reasonably related to the physical health of the pregnant woman. In the third trimester, the amendment allows the regulation or prohibition of abortion, except in cases where an abortion is necessary to preserve the life or health of the pregnant woman. That determination must be made by the pregnant woman's physician.
Tonight's half-hour discussion will be structured similar to a debate, but we want it to be more of a conversation. We do have a series of questions for both participants. There is a loose time limit for answers, but we want to allow for both substance and context. If we feel we need to move the conversation forward, we will ask you to wrap up your answer. We may ask for clarification on an answer or allow for brief rebuttals. We will also have opening statements, but there will be no closing statements.
The order for opening statements was decided by a coin flip before we came out. John, you'll go first. You have 90 seconds.
Well, first of all, I just want to say thank you both for hosting tonight's forum, and thanks to Dakota News Now for putting this on. I think it's a really important topic of conversation to discuss. And, you know, as I've talked to just countless South Dakotans about the issue of abortion, one of the things you find really quickly is that there's just a broad range of opinions on this subject. Anywhere from, you know, people who don't want any abortion to maybe some abortion in the early weeks of pregnancy, to some people would support exceptions for rape and incest. I get those positions. I understand those positions. With Amendment G, it goes way beyond any of those positions. If Amendment G is written into our state constitution, what we're going to have instead is abortion after the baby is viable, all the way up to the 9th month. And because Amendment G is written into the state constitution, it overrides all of our existing common sense bipartisan statutes that we have on the books today. So for example, if Amendment G is written into our state constitution, parents' rights to know if their minor daughter is undergoing an abortion would be eliminated. Amendment G would be the first time in the state's history that parents' rights would be eliminated by a constitutional amendment. And because of the way it's drafted, it's sloppily written, it even overrides basic health and safety protections for women. Things like ensuring that abortions are done by a doctor at a licensed and inspected facility. Those common sense bipartisan protections for women that we've had in our laws in South Dakota are overridden by Constitutional Amendment G. And I think that's why we're seeing, as more and more people learn about the truth of Constitutional Amendment G, they realize it's too extreme and they're rejecting it.
Nancy, you have 90 seconds.
I'm here not just as an attorney and a former professor of reproductive law, but especially as a mother and a grandmother and a lifelong advocate for women and children in South Dakota. And I support Amendment G because it restores freedom. Freedom for South Dakota women, personal freedom, and professional freedom for South Dakota doctors. We have an extreme abortion ban. there is no exception for rape and incest. There is no exception for the health of the mother. It threatens doctors with prison if they deliver services to a patient that they believe in whose best interest it is to get those services, but the legislature didn't want her to have them. And it even confuses miscarriage care. Nobody wants this. Nobody wants an extreme ban. South Dakotans want moderation, a compromise. And that's what we had from Roe versus Wade 50 years ago, and that's what Amendment G restores. Larger personal freedom early in pregnancy, greater regulation as pregnancy progresses. Amendment G balances. It's a balance. It protects families and health, but it also respects the freedom of women and families and doctors. Opponents falsely claim that Amendment G is extreme. It is not. They're spending millions of dollars to misrepresent the facts and lie to voters. And I'm glad to be here tonight to try to set the record straight.
Let's move on to the discussion here. Nancy, since Dakotans for Health is the group sponsoring the amendment, we're going to begin with you here. Amendment G says the state may not impose regulations on the carrying out of an abortion. So how is that going to play out as far as protecting women's health if they choose to have an abortion, if there can be no safety regulation?
It doesn't say there can be no safety regulations, and I'm so glad you asked that. There can be no regulation of abortion, but this does not eliminate, as John claimed, it doesn't eliminate general health and safety regulations. It doesn't change parent-child law. It doesn't change the requirement that doctors have a license before they practice medicine. Those general health and safety regulations and those other general laws will still be in place. It's just the specific kinds of regulations that the legislature has thrown up over the years that are trying to obstruct doctors, restrict their practice, and frankly frustrate patients that would be vulnerable to not being enforced in the first trimester. And of course, in the second trimester, the state can regulate as it likes, specifically regulations of abortion, as long as it's for the physical health of the mother.
Now, John, you disagree with that, as you just mentioned. You've argued that Amendment G would open the door to a wild, wild west, that it takes away health care protections for women in the state of South Dakota. But the state of South Dakota already has laws that ban people from practicing medicine without a license. What do you mean when you say women will have fewer protections if Amendment G passes?
Well, here's a really good example of that. So there are specific laws that the people of the state through its legislature have put into place to protect mothers from unsafe, low regulation abortions. And so one example of that is when it comes to chemical or pill form abortions, because one of the things that the abortion industry has shifted to over the last decade or so is more chemical pill form abortions. And so what we discovered is that the abortion industry was basically just giving these pills out and then leaving mothers to take them in unsupervised settings without doctor supervision. That is extremely dangerous. These chemical abortion pills have serious risks, including death, when it comes to side effects in taking these abortion pills. And so the legislature said, well, because that's happening, we actually want protections for mothers to make sure that doctors are properly overseeing these sorts of abortions. And so, led by Governor Noem, the legislature put those protections into place. Now, that is a regulation specifically on the effectuation of an abortion, and it's in the first trimester because that's when those kinds of abortions would occur. And it's that kind of law and other kinds of laws like it that would be overridden, canceled by Amendment G. That's not just a medical, it's sort of a general medical law. That's a law that was passed specifically related to the issue of abortion because we found that these were being done unsafely and unsupervised in the state of South Dakota. So it's laws like that that will be overridden if Amendment G is written into our state constitution.
So you say the laws will be overwritten if Amendment G passes. What do you base that on?
A great question. So we have to remember that when a constitutional provision, when it conflicts with other state statutes, that constitutional provision is always going to override the state statutes. That's how the constitutional law sort of relates to state law. And so when you look at the amendment language, when you look at the language of Amendment G, it says that before the end of the first trimester, the state may not regulate a pregnant woman's abortion decision and its effectuation. In other words, the bringing about of an abortion, which must be left to the judgment of the pregnant woman. That is a blanket prohibition on any regulation related to the bringing about of an abortion. And so that's where, in that language, you have the constitutional provision overriding common sense bipartisan protections that this state has had in place for decades, including health and safety protections for mothers, including laws protecting parents' rights to know when their minor daughter is undergoing an abortion.
Can I respond to that?
How about a brief rebuttal? Sure.
Sure. Well, let's talk about parents' knowledge and doctors performing abortions. We know from the 1970s that the Supreme Court of the United States already addressed those issues. And they held that even when there's a constitutional right to abortion, states can still require that doctors perform abortions. States can still require that parents consent to abortions for minors. So that's, John and the rest of the legislators, if they bother to read the history of abortion law, know that that argument is false. And as for medication abortion, I think we should be honest here. The medications they're talking about are medications that have been approved by the FDA for decades. They've been used in various circumstances, and they've been used in abortion care for a long time. It's ludicrous to suggest that somehow the South Dakota legislature had greater expertise to decide about the safety of these drugs. If we're honest, it was just another effort by the governor and the legislature to frustrate the will of the people. And there's absolutely no reason that those drugs, they're not over-the-counter drugs, they have to be prescribed. So it is medical care, and it will be regulated.
Nancy, let's talk about the language in Amendment G. Amendment G allows for the state to prevent abortion in the second trimester up through 6 months only if it relates to the health of the mother. Otherwise, abortion must be allowed through the end of 6 months. What sort of restrictions that are related to the health of the mother would this cover?
Well, I think probably one you might expect would be that if there was a second-term abortion, maybe perhaps restrictions on the facility. For example, maybe I know that there's currently a statute that requires, a blood bank available, some sorts of things like that. But the restrictions that the state might choose to regulate in the second trimester are really not, I don't think they're really much of a point of contention. And in fact, second trimester abortions themselves are very rare. But I think for the most part, you would probably be talking about procedures in a hospital.
Okay.
John, according to the South Dakota Department of Health, South Dakota has a rape rate that is, quote, considerably higher than the national average. In fact, it's been estimated that since the Dobbs decision and South Dakota's trigger law went into effect, an estimated 1,300 rape-related pregnancies have happened in South Dakota. So what do you tell women who, under South Dakota's current abortion ban, must carry these pregnancies to term?
Well, I think it's really important to remember that if you look at the actual text of Constitutional Amendment G, that the word rape, the word incest, those exceptions, they don't exist in the text of Constitutional Amendment G. And so I know that those issues are being used like a political tool, but the reality is that this is not just about rape and incest exceptions. If you, like a lot of South Dakotans, think there should be rape and incest exceptions, again, I understand that position, but that's not what Amendment G is. If Amendment G wanted to be about rape and incest exceptions, it would have written rape and incest exceptions into the law, but it doesn't do that. And instead, what it does is what we've been discussing, which is abortion through all 9 months of pregnancy and taking away these basic protections, these basic bipartisan laws that we've had on the books for years and years. And so I think there needs to be, and there will continue to be, a very robust conversation about what our law in South Dakota should look like in terms of rape and incest exceptions, but that's not what we have with Amendment G, and that's very important for the people of this state to know.
But in the meantime, in absence of Amendment G, in absence of Roe versus Wade being legal here in the state, these women have no avenue. They have no venue. There is nothing available to them if they find themselves in this situation.
Well, and again, Brian, I think that that is a conversation that is going to continue to move forward in the state of South Dakota in terms of setting up what a lot of people would say is a reasonable, rational approach to abortion laws. but that's just not what's on the ballot today. What's on the ballot today is way more than that. And so if you want to have those conversations, and a lot of people do, and I understand that completely, if you want to have those conversations, Amendment G is not the forum for that. Amendment G should be defeated because it goes way beyond that. And then you can have those conversations about what reasonable abortion policy should look like in the state of South Dakota.
I've got this next question for both of you, and Nancy, I'd like to start with you if I could. How should the state balance a woman's interest to control her body with the state's interest in protecting the unborn? What is the middle ground? Is there a middle ground?
This is the middle ground. This is the middle ground. And first I just want to correct something that John said, or at least explain it, because I don't think we should be playing word games here tonight. Rape and incest are not mentioned in the amendment because if you get rid of the ban, you don't need an exception for rape and incest. The reason you need an exception is because we have this extreme ban. But in terms of how should it should regulate the way 7 out of 9 Supreme Court justices decided back in 1973. And they were religious, conservative veterans, many of them, and they decided the best way to do it was on a trimester system, so that in the early stages of pregnancy, there's very little or no state regulation, specifically of abortion. And as the pregnancy progresses to the middle trimester, the state can regulate to protect the health of the mother. And in the final trimester, the state can absolutely prohibit it if they want, as long as they leave an exception for those few cases where an abortion is necessary to save the life or health of the mother.
John, I want to come back to you on this, but also with this caveat, building on what you said earlier about there can be a robust discussion. There likely will be a robust discussion. If memory serves, there has been a robust discussion. I think Taylor Rayfeld from Sioux Falls has tried to bring it up to the legislature. Aaron Tobin, I think, has tried to bring it up to the legislature. And it has gone nowhere. So why should voters believe that if G is voted down, that the legislature will take any meaningful action when they've had the opportunity to do so and they've not done so?
Well, I do want to address one thing, and I'll get to your question, Brian.
Sure.
I do want to address one thing that Nancy spoke to earlier, and that is this trimester framework. This trimester framework was actually thrown out in the early 90s, decades ago, as unworkable and unconstitutional. So there's been a lot of talk about restoring things how they were before Roe versus Wade was overturned, but that's not what this language does. This language, or something similar to it, was actually thrown out by a moderate Supreme Court as unworkable and unconstitutional. So all of this talk about we're going to just go back to how it was before the Dobbs case overturned Roe versus Wade, that's false. That's not actually what Amendment G would do. So to your question, Ryan, I was involved with some of those discussions. I know a lot of legislators were involved in some of those discussions. And I just think that, we're a couple years post-Dobbs, and I just think those conversations are going to continue to take place. There's no doubt in my mind that there's going to continue to be robust conversation on this issue. And I think that post-Amendment G, there's going to be a lot more concerted discussion about what our laws should look like. I think there will be legislators dedicated to bringing up this issue and really just having an open and honest conversation about what that should look like for us.
Brief follow-up. For the folks that are watching this issue and they're very concerned about it, they will say to that, we don't want talk, we want action.
Yeah, right. I understand that, and I think that you can expect that.
I'd like to, could I address that?
Briefly?
Sure. And first of all, Roe versus Wade was not thrown out by the Casey decision. It was reaffirmed. And if it had been, we wouldn't have had Dobbs having to reverse Roe versus Wade. But in terms of legislative action, I have to think of my dad always said, hey, you're a day short, a day late and $1 short. South Dakota legislators have known since 2006 that South Dakotans do not want this ban. They were told again in 2008 that they don't want a ban, even with a rape and incest exception. And polls since then have shown that. The legislature's had plenty of time to fix this if they wanted to. And just this summer, I asked for a special session so these guys would take a look at it. They completely ignore it. They're not going to do anything. And the legislature has disregarded the people for 20 years on this issue. We can't rely on them, and that's why it's a constitutional amendment.
Can I say something about that real quick? Because I do want to respond. This trimester framework was thrown out by the Supreme Court, and you can fact check that and look that up. This trimester framework was thrown out by the Supreme Court as unworkable and unconstitutional. That's a fact. And so all of this talk, again, about going back to how it was before Roe versus Wade was overturned in the Dobbs decision, that's just false, because a trimester framework was overturned by the Supreme Court.
Nancy, in talking about that, Roe v. Wade talks about fetal viability, which Amendment G does not.
Correct.
Why is that?
Well, I think that's a good question. I didn't draft it, so I don't know that I can give you the best answer. But I think the desire of the drafters were to adopt the system that indeed had governed us for 50 years. Frankly, a lot of out-of-state entities, I think probably the American Medical Association, ACOG, and some others would have liked a much more liberal amendment. But the folks that were proposing this decided the best thing to propose to South Dakotans, where we all want conservative, moderate measures, was to present the moderate compromise that dates back to the Roe versus Wade decision, and that was done in terms of semesters. Trimesters.
Trimesters. Because fetal viability has changed in the time since Roe v. Wade was decided 50 years ago and now. And the fetal viability framework is not included in Amendment G. Would you have liked to have seen the fetal viability language included?
Not necessarily, and these are issues of kind of academic interest, but they aren't of very much practical significance, and here's why. About 95% of abortions in South Dakota and elsewhere take place in the first trimester. Nobody's going to argue that a fetus is viable at 12 or 13 weeks. And in the second trimester, typically, those few abortions that occur are in situations where the family very much wants a baby, but a 20-week anatomy scan reveals fetal abnormalities, and those situations are typically what account for those abortions. So while it's kind of interesting maybe for lawyers or others to talk about the different framework, the practical effect is that I don't think it really would make any significant difference if Amendment G were worded in terms of viability.
Well, Alicia, can I respond to that? Because I actually do think you're touching on an important point to a lot of South Dakotans, because a lot of South Dakotans are very uncomfortable and actually don't support the idea of legal abortion after the point of viability, after the baby is viable outside the womb. So I think you're touching on a topic that actually resonates with a lot of South Dakotans, because most South Dakotans wouldn't support a measure that legalizes abortion past the point of viability. Amendment G doesn't discuss that, because Amendment G actually does legalize abortions past the point of viability, which most South Dakotans just don't support.
But it trusts doctors and mothers to make the decision. And what I'm telling you is that any of these abortions that you're talking about, it really isn't viable anyway. If you have a couple that learns that their fetus is not going to develop a skull or a brain, it's perhaps past the normal viability, but the issue for that couple, sadly, is do they carry it to term and watch their baby die in the first few hours, or are they allowed a different choice? And right now, South Dakota doesn't give them that choice.
Well, let's kind of get to the crux of these things. John, I'm going to start with you. What do you think are the biggest misconceptions that are being told to voters about Amendment G?
Well, a few very important things come to mind, and there's some of the things that we've talked about tonight. That, the fact that Amendment G does legalize late-term abortion after the baby is viable outside the womb. Proponents of Amendment G are saying that's not the case. That clearly is the case under Amendment G. Amendment G also does, as we've discussed, override those existing bipartisan common sense protections, both for mothers and babies. The proponents of Amendment G are saying that's not the case, but it is the case. That's true under Amendment G. But I think there's also an even sort of bigger picture misconception that's put forward by the abortion industry. And I just want to speak to that a little bit, because I know that there's probably a lot of South Dakotans who have been affected by abortion. There's probably a lot of women tonight who are listening to this conversation who have been affected by abortion, who have gone through an abortion. And I know that when those topics come up, sometimes for some women in this state, it elicits sorrow and regret. And that's one of the misconceptions that the abortion industry doesn't like to talk about, that there actually is deep sorrow and regret associated with some people having gone through an abortion. And if that's you, if you're listening to this and that's you, you should know that you're loved, that you're not judged. And the co-chair of this organization that I'm representing tonight, Life Defense Fund, her name's Leslie Unruh. She's dedicated her whole life to counseling mothers who are considering an abortion and mothers who have gone through an abortion and have lived with silent sorrow and remorse for having gone through that decision. And if that's you, if you're experiencing those emotions by hearing these conversations throughout the state, I just want you to know that you're loved, that you're not judged, that help is available, resources are available to you. Please reach out to the Alpha Center in Sioux Falls. Know that you will be treated with the love and dignity and respect that you deserve, and that help is available if you need those resources.
Nancy, I'm going to give it to you now. What do you think are some of the biggest misconceptions that are being told about Amendment G?
Well, I wasn't going to list this, but I'll start with this. The misconception that there's an abortion industry, that apparently must have turned up in some focus group to be a useful term for opponents to use. We're not talking about an abortion industry. We're talking about South Dakota doctors and patients. The doctors heading up the Doctors for Freedom are a doctor from right here in Sioux Falls and Sanford, and retired OBGYN from Rapid City, Marv Beener. But the biggest misconceptions are these. One, this nonsense about abortion up to birth. Amendment G does not extend by even 1 day the time period during which abortions can be performed, not by 1 day. And when you're in the 3rd trimester, the standard is exactly the same as it was under Roe versus Wade and continued for 50 years. So there's no abortions up to birth that are coming. It didn't happen in the last 52 years, and they're not going to happen now. If a woman is near term and her pregnancy needs to be cut short, the doctors deliver a baby. They don't abort a fetus. The second biggest lie, and one that seems to be really being pumped out now, is this business about parental consent. Parents generally have the custody of their children, and part of what goes with that is the authority to control their medical care. You can barely get the school to give your child an aspirin without parental consent. You're not going to have abortions without parental consent. Again, that was already decided in a case called Bellotti versus Baird in 1975, I think it was, that a constitutional right to abortion does not interfere with the parent's rights. The third, probably most offensive lie that's being told is this nonsense that you don't have to be a doctor, that anybody could perform an abortion. That's not true. Abortion is medical care, and you have to be licensed as either a doctor of osteopathy or a medical doctor to practice medicine in South Dakota, and that won't change. And I guess when I looked at their website, the last sort of, lie I would say is kind of a general complaint they have about ambiguity. They complain that nobody knows what the term health is. Well, health is used. That term is used 3,000 times in South Dakota statutes, John, and about another 1,000 in South Dakota regulations. They complain about the term effectuation. That term has been in South Dakota abortion statutes for decades. So it just seems like they've realized that South Dakotans will not accept a total ban if their only argument is that there should be no abortions. And so instead they've cooked up all these other lies to try to scare voters.
Well, thank you both for being here. That'll do it for our discussion this evening. We'd like to thank both of our panelists for joining us in studio. We hope this conversation brought some clarity to many voters who may have been undecided.
Yeah, and if you missed any of tonight's programs, we want you to know that you can find it online at dakotanewsnow.com and also kotatv.com. And you can also find our coverage from Matters of the State on each of the 7 ballot measures online at both of those websites.
One final reminder, Election Day is Tuesday, November 5th. The polls will be open from 7 a.m. to 7 p.m., but early voting has already begun and goes until November 4th.
Nancy Turback and John Hanson, thank you so much for making time to spend some time with us this evening talking about this.
Thank you.
And thank you for joining us. And as we say, from all of us to all of you, good night.